All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is State of Florida versus DV.
May it please the court, my name is Ramey Sheris-Turkin for the state of Florida. I ask to reserve 5 minutes for my rebuttal time. DV asked the 3rd District Court of Appeal to review the denial of his motion for judgment of dismissal on his conviction for actual ready-reach possession of a firearm by a minor. Instead of applying the standard where the court, while reviewing de novo, takes all facts and inferences in the state's favor and looks for competent substantial evidence that the state presented a prima facie case, the 3rd District Court of Appeal cited to a number of constructive possession cases that require independent evidence of control when contraband is in a jointly occupied area.
Counsel, do you agree, though? Do you believe that this is an actual possession case or a constructive possession case?
The trial court found that this was an actual ready-reach possession case, and we believe that it was an actual ready-reach possession case.
Detective Buchanan and Detective Torres both testified that the gun, the firearm, was neither in the possession or control of DV. It was not found in his hands, or they didn't have any testimony that he actually had possession of it. So actually, how is it an actual possession case?
Actual possession, ready-reach, requires that the property be so close to the person's possession that it be within their ready reach and their control. The detectives testified that the firearm, one of the detectives testified that the firearm was 6 inches from DV's thigh, and the other detective testified that the firearm was within DV's arm's reach.
Well, Detective Buchanan testified that the gun was 2 to 3 feet from the gun, and Detective Torres testified that it was within inches, and it's a white Audi, it's not a big car, correct?
I'm not going to agree that there's evidence in the record as to the size of the car, whether it was big or not, but taking all inferences in the state's favor, while reviewing the motion for judgment of dismissal, the firearm was within 6 inches, which is the closest testimony. 6 inches is not very far.
Right, but the gun was found in the rear passenger, behind the driver's side, correct?
The gun was found 6 inches from DV's left thigh on the bench. And
but he was not sitting behind, he was sitting behind the front passenger, not the driver, correct?
Correct, Your Honor.
Right, and there were 2 other people in the car.
They were in the front seat.
What evidence in the record exists that the gun was not in the dominion or control of the 2 passengers, the driver or the front passenger in the vehicle?
There was no movement from the front passengers at any point.
Was there movement from DV?
There was no movement from DV, but DV was sitting so close to the firearm that he was the only person.
So let me ask you a question. Is it the state's position then that the law of the state of Florida should be that now anyone who gets into a vehicle as a passenger in the back seat should now have and make sure that there is nothing contraband or illicit material in the back seat of a vehicle? Because if you're sitting now in the back seat of a vehicle pursuant to what the state is asking this court to do, then you will be within the dominion and control of the potential contraband.
This was a firearm. This was a Glock, which is a very large gun. This was 6 inches from DV's thigh. Knowledge is not a dispute.
But the state has an obligation to show dominion and control, correct?
The state does have an obligation to...
What does the record show is the dominion and control of DV for this firearm?
The firearm was within DV's arm's reach.
Is mere proximity sufficient?
This was not a mere proximity case. Under RDD, a person in the exclusive control of the back seat has exclusive control. The mere
So
proximity...
is it your position then that a driver cannot go back and put something in the back seat?
A driver to reach, or the driver or the front passenger in this case, would have had to twist and contort their body and go outside of the natural place where an arm's reach goes. The front of this podium to the back is twisting and contorting. Where my arm goes naturally
Perhaps
like
if it's a
this,
minivan, but in a white Audi, I don't think so.
The
The
bubble-
testimony is it's a white Audi, correct?
The testimony is that it is an Audi. I agree with
Right.
that.
It's not a Ford Explorer, it's not a Suburban, it's not a large vehicle.
So
We don't
in-
know the dimensions of the vehicle.
We don't know the dimensions
The
of the vehicle.
external dimensions or the internal dimensions.
We don't.
But, I mean, as a matter of common knowledge, we know there are big Audis and there are smaller Audis, correct?
I'm not familiar with
You've never seen the smaller one?
the smaller one. I'm sorry. I apologize.
I guess that knowledge is not as common as I thought.
So RDD also doesn't contain information about the dimensions of that car.
And
But in-
excuse me, can we just kind of back up for a sec? Can you just kind of elaborate on what your understanding is of what dominion and control means? Because I think that might help.
So it's
sort of-
for ready reach. Ready reach is the ability to just put one's hand out. State v. Williams defined, State v. Williams, which was an actual possession case, defined the zone of control around your body as just the place where your hand goes naturally. And control is the ability to exclude others from it and to put one's hand and
So
to have
if the vehicle, let's say the owner of the vehicle had a firearm in the back pouch, the one that's behind the seat where you put things in, and I'm sitting in the back seat, I can just reach in that back. That's within my reach, isn't it? And it's not even my gun.
In the back pouch, though, there would be a knowledge issue. Knowledge is not in dispute here because
Okay.
the firearm was uncovered, and it was right where
Well,
one's
let's
hand
say
would go to use it.
let's say the firearm is sticking halfway out of the pouch with the handle coming out, and anyone sitting back there would see it. Does that make me in control? Does that
The
put
back
me in
pouch,
possession of this firearm?
the back pouch would be equally accessible to both the driver and to the back seat
How is it
rear
not
passenger.
equally accessible to the driver in this case or the front passenger in this case? Because DV, Detective Buchanan testified that DV was behind the front passenger. They were not behind the driver, and the gun was found behind the driver on the seat, correct?
Detective Torres testified that the firearm was 6 inches from DV, and
Was-
Detective
You can
Buchanan...
answer the question. The question was the gun found behind the driver's side on the seat?
The gun was found on the bench behind the driver's side, but also next to DV, who had sole and
So
exclusive control
is there
of the
evidence
backseat.
in the record that showed that the passenger on the front side of the car did not have the ability to reach for that firearm?
The issue is, was it in DV's zone of control, the bubble where his arms naturally move? It was not in,
But there is no evidence. It was within his reach, but how do we know that it was also not within the reach of the passenger on the front side of the car?
I submit that the line of cases from the First District Court of Appeal, RDD, State v. Williams, Smith v. State, get it right, that there is a difference between a place in a car such as a cup holder or a console or
Well,
a
let me ask you a
dashboard where
question.
everyone can
You
reach.
get into an Uber car, all right? The driver is driving, and you're in the back seat. Under your scenario, I'm in exclusive control of the back seat. There happens to be a baggie on the floor. It's a baggie of cocaine. The police stop the Uber driver. Is now the person, the passenger in the Uber car, are they going to be now charged with possession of contraband?
I have a number of reasons to differentiate that fact pattern from this case. First of all, the car here was never moving. The police saw the car twice, and the reason they stopped
Okay,
it is
the
because
Uber
it was stopped in a
driver, the
roadway.
Uber driver is stopped.
Second, the contraband in Your Honor's scenario is a small baggie of drugs, which is very different from a very large loaded firearm that was 6 inches.
That's what the contraband was in Robinson. They found the contraband on the floorboard where the defendant in the case had been seated, and when they got out of the car, that's where they found it. Therefore, Robinson, that was sufficient. So under her scenario, Robinson would say he's guilty.
And further,
I guess the passenger in the Uber car is not going to jail for possession of cocaine.
there's one more fact that we can differentiate it. I submit that a floorboard may be different from the back seat. A
Okay, it's
floorboard
on the back,
requires
it's on the back
twisting.
seat. It's on the back seat. I'm a passenger, or there's anybody sitting here in the audience, is a passenger in an Uber car. They get in, they see a baggie there, or they see a package there, they don't know what it is, they don't say anything, because they just want to get to their destination.
They're choosing to exert control over the contraband. The contraband is in plain view, so we know from Brown that
So now
knowledge
they're
is not in
exerting
dispute.
control over something that they have no idea, they didn't put it in the car, so now that's their position. I just want to make it clear.
The issue is not ownership. The issue is control. And when the police stopped the vehicle, DV was in control of the
All
firearm.
right, so to accept your position, I think we will have to arrive at the conclusion from all these cases, in a situation where you have a backseat rider and no one else in the backseat, that the person sitting in the backseat automatically has exclusive possession of anything within his reach, which would have to be the entire backseat. They're not that big.
That is what.
That's what you're saying.
That is what the First District Court of Appeal
Well, I
holds.
know
and we
that's what,
submit
I
that
know
it-
that's what the first said, but the other courts haven't said that.
That sounds like that's a much broader, I mean, the facts here isn't just anything in the back seat of a car. I mean, we're talking about a gun that's pretty much adjacent to someone's leg in plain view. I mean, so,
Exactly. We're asking the court here to find that the Third District Court of Appeal erred in applying the constructive possession cases to this actual possession
But
scenario
how did you?
when the firearm
But
was
how
so
do you,
close.
what is the record evidence to show, other than mere proximity, and that it was within, in the back seat, that gun was within, it was controlled by DV, and that it was not placed there by another passenger, that he happened to know? The intent, the knowledge is there. He knew it was a gun. It was in plain view. But it's more than that. It's more than knowledge. It also has to be dominion and control. And so what I'm asking you, is it your position, is the state's position, that dominion and control is, you can show dominion and control by the fact that you have knowledge that that is contraband and that is within your reach? That's really what I'm hearing you say, but I want to hear maybe I'm misinterpreting.
It's our position that when you are in exclusive possession, either you are in exclusive possession, you're in actual possession within your ready reach. The contraband that is located there is yours.
What if the driver and the passenger in the front seat, before the police arrived, said, that's our firearm, we're putting it back there. How old was the defendant in this case?
He was 15 at the time.
15. Don't touch that. That's ours, we're putting it there, don't touch it. Police arrive, it's still there on the back seat, but the result of this is he's in possession. So to what extent does age of a defendant enter into it, or in that scenario, how would this play out?
Well, under the don't touch it scenario, that could be a defense. But the question here was, did the state
So the
present
defendant needs to testify to be able to say that?
I'm not suggesting that, but the ownership of someone else could be a defense. But again, ownership was not the question here. Control was the question. And he could have gotten out of the car, the vehicle was never moving, or in some other way disclaimed.
Isn't the state under a burden of proof to show that it was in his possession as an element of the crime?
The state's burden of proof for an actual possession was ready reach and control. And it was within his ready reach. If the front seat passengers had exerted control over it, which there was no evidence here that they had,
No, but the
he
state,
could have stepped away from it.
The only testimony, and in closing, the only evidence you had of dominion and control was proximity. That was it. There was nothing more. There was no further evidence. And in fact, the prosecutor, that's what they argued. The fact that the gun was near him, that was it. That was dominion and control. He knew it was there. That is it. There is no other evidence, unless you can show me other evidence.
That was the evidence, the 6 inches from his thigh, and that he was in exclusive possession and control of the area around him. And that was sufficient to
In my
survive.
example, how would the defendant put on the defense?
I'm not suggesting that he needed to put on a defense, but I'm suggesting that it was a defense. There could have been some proof of ownership, but again, that was not the issue here.
Well, there was another person who was speaking to I believe, the front passenger. He was standing outside talking to him. And I believe the testimony, not at this hearing, but later on in the case, was that that person had been sitting in the car and got out and was just talking when the police got there. Well, I mean, that could have been his gun. He dropped it and left it there.
And then ran into his house.
And ran into his house because guess whose gun it was?
So respectfully, there was no testimony that he was ever in the car. To the contrary, the testimony was that he did not reach in the car and was never seen in the car. So that begs the question, was this a circumstantial evidence case or direct evidence case?
And didn't the state also argue in closing, which I think was burden shifting, that DV did not show that neither the driver nor the front seat passenger had dominion or control or could reach for the gun? Isn't that your burden to show?
It is the state's burden to prove ready reach possession and control.
Did you show that the driver or the front seat passenger did not have ready reach? I believe you didn't, but maybe I read the record incorrectly.
We did show that they did not have ready reach because for the front seat driver or passenger to reach this firearm, they would have had to twist their body. As to the fourth person outside of the vehicle.
Where is that in the record? Because I did not see that. No one asked the police officers, either Detective Torres or Detective Buchanan, that question.
I think it was transcript page 48. There was a testimony that there was no movement inside of the vehicle. No movement meant all three people.
Well, how does no movement show that they didn't have the ability to reach for the gun? That's very different, isn't it?
But it would not have been an easy reach. It would not have been ready reach
Let
within
me
where
go
the
back
arms
to my
naturally move.
example a moment ago. If they told the defendant, don't touch that. In that example, is there control and possession by the defendant?
The defendant continues to sit next to the firearm. He continues to sit next to it. He continues to be the one who has the physical ability to reach out and say, I am touching it. It's my firearm. I'm going to sit behind you with the loaded firearm. I'm not going to listen to you.
So there is possession in your view?
In my view, he still maintains possession and control of the
Wouldn't you
firearm.
ag-
Back to the fourth
Wouldn't you
person.
agree, though, that for actual possession, the control has to be intentional?
That goes to a knowledge question. And here,
No, I mean, because he obviously knew it was
Obviously.
there, it's in plain sight. But doesn't the control have to be intentional? Don't you have to intentionally control?
an intent is one of those
I mean, we
types
did-
of proof that can be inferred.
We did in 2018 change the possession jury instructions, and it now reads intentional control, and nobody commented that that was inappropriate, no prosecute anybody statewide. So, I mean, that's how jurors are instructed now. I think that was implied before, but is it your position that you don't have to intentionally control?
It's not my position, but intent can be inferred from the circumstances, and at the motion for judgment of dismissal stage, all inferences are drawn in the state's favor. So the fact that he was sitting next to a firearm and he was alone in the back seat next to the firearm,
But
and it was
you-
so close to him,
I mean, if you would agree that if there is a reasonable theory under which the defendant didn't intentionally control, such as Justice Polston's hypothesis, that wouldn't survive the motion for judgment of acquittal, because in order to go to the jury, you have to present evidence from which a jury can find beyond a reasonable doubt that the defendant intentionally controlled, right?
I think it still would survive the motion for judgment of dismissal, and then it would be for the fact finder to decide whether the circumstances and the evidence proved the case beyond a reasonable doubt, or if one of the defenses, such as it was someone else owned the firearm, someone told me not to touch it.
I mean, if the law is as you say it is, then you just control it because it's within ready reach, even if it might not be yours, even if you might have been told not to touch it.
Again, so RDD, to address the question of whether the baggie of drugs was tossed onto the back seat by one of the front seat drivers, and the First District correctly pointed out that's an issue for the
let me
finder of
ask-
fact as to how the drugs got there isn't the same as did RDD have actual possession or
Let me ask you
constructive
one more
possession there
question.
at that time that the police stopped the
I know
vehicle.
you're running out of time, but
Sorry.
if the state had done a fingerprint test on the firearm and it had the driver's fingerprints on it or the other front seat passenger, but not the defendant's, what would your position have been at that point?
Taking that hypothetical, I don't believe that that would have changed the fact that at the moment that the police stopped the vehicle, RDD was in ready reach of the firearm. Who had ever touched the firearm or who owned the firearm wasn't the issue. The issue was, did he at that moment have control of this large, dangerous, loaded weapon? And he had control to the exclusion of the others. If someone had turned around and twisted, remember, he could grab the firearm. He was sitting behind them. He was the one with the closest ability to control it.
But the problem I have with that is, going back, the Uber driver picks me up. I get in the back seat of the Uber driver and start to drive away, and he gets pulled over in the next block. And there's a gun right there. I had not seen it yet. Right there, behind. Somebody, whoever was there, left it behind. Or maybe the Uber driver kept it and it fell out, whatever. It's right there. I get in the car. Police officer pulls me over right there. The Uber driver, right, comes over. There it is. I'm guilty under your scenario, just because it's there. And I'm in the back seat, and you have put me in possession of the entire back seat of this car. That's the conclusion we're going to have to reach to agree with you.
The state would have proven a possession case because knowledge is in dispute. It is not in dispute, it is uncovered.
So you would have prosecuted the Uber example.
It seems to me, unless you could have, if you didn't see, if you saw it, you see it, it's in knowledge. Knowledge is not in dispute, it's uncovered, it's right there. You're alone in the car. And also, there was no evidence here that this car was an Uber or was a car for hire or was driving.
But if we write an opinion, it's an opinion and it applies to all motor vehicles. I mean, it's not going to be based on just, exclude Uber and Lyft vehicles.
Can we just, though, for the record, just clarify, your position is not that anything that could possibly be in the back seat of a car is necessarily under the control of someone who's the only person in the back? Just to answer Justice Labarga's question.
My position is that anything within a person's ready reach, especially when they are in the back, the sole occupant of the back seat of a car, it would be different if.
Well, that would be the entire back seat of a car.
But it would, if it,
I can reach anything in the back seat.
it would be different if there were 4 people in the car and then both occupants had equal reach to it and had the equal ability to reach it. But when DV was the sole person. and
Okay,
he
counsel,
wasn't there-
Can we just clarify, though, your position, as I understand it, it's not even something generic about back seats of cars. We're talking about a specific fact pattern of a gun that's inches to a foot away from someone's leg. Your position is just that under that specific fact pattern, that is what would constitute control.
That is correct. That is our position.
All right.
All right, counsel, you have exhausted all of your time for rebuttal, plus a little more. But because we helped you a great deal in doing that, I will afford you 2 minutes for rebuttal.
All right, thank you.
Mr. Chief Justice, and may it please the court, I think the rule that you have heard today is untenable in a number of respects and ultimately will result in the wrongful conviction of people who are simply present while other people are committing crimes, or in a case like this, simply has an item that is not in and of itself illegal, is simply a firearm in the backseat. I want to start with a factual correction. The facts of this case are not that it is 6 inches away from my client's leg. As found by the actual fact finder of the case, 1 to 2 feet. So 1 to 2 feet looks something like this in the small confines of the back seat of a car. Your jury instruction 10.15 says that mere proximity to a firearm does not establish that the person intentionally exercised control over it in the absence of additional evidence. That's been the rule in this state for nearly 50 years. It's the proper rule because it protects people who are innocent and who are simply there. And I think any other rule would upend that and effectively would eviscerate basic constitutional protections that people enjoy, like the beyond reasonable doubt standard, and the fact that Florida law and American law has always rejected this notion of guilt by association. I think, though, largely our argument and the reason that all of the courts to look at this, except for a single outlier, have gone the way of the criminal defendant is because of common sense and social custom. If, for instance...
Let me just, I am sympathetic to the state's argument in the sense that when you have a firearm that you can grab without even moving, and whether it's 6 inches or 1.5 feet, And I think the reason probably that it's illegal to have, carry a firearm in a car like that, I mean, we're concerned about public safety, including that would mean that the law enforcement officers, as they approached, there would be no law that would prohibit a person from having themselves in a place where they could just readily fire at a law enforcement officer when they approached a vehicle at a traffic stop. But your argument is that there's no way to prevent that. The backseat passenger could always have a firearm sitting right there despite the law and could, and that could be a problem. I mean, I could see why the legislature might want to prohibit someone from being able to just drive around in the backseat of the car with a firearm sitting next to them. And control, as a practical matter, I think that is, I mean, we would all say that, yeah, you control that if you can just grab it, right? So why isn't that ready reach control as a matter of law? If there's nobody else that can just grab it without even moving their body, and you can grab it without moving your body, you can exercise actual control. You could fire it in an instant. Why isn't that control as a matter of law?
Justice Lawson, let me start by pointing you to the language of the jury instruction that the state is relying on, which is that for the actual reach theory of possession, the person must be so close as to be within ready reach, and the object must be under that person's control, which I think means that merely being within actual reach is not enough to establish control. Control is something different, and I think it's a matter of largely social custom, and I could illustrate that with a hypothetical. If I get into the back seat of my friend's car, I have a license to sit in the car and travel to my destination. I do not have a license to take my friend's laptop that sits 1 to 2 feet from me and to begin typing away on it. And that's a matter of common sense. I don't control what someone else owns and is in the back of the car. Just like in Justice Polston's hypothetical, the gun is in the back seat, but the child in the back does not have the right to actually exercise control over it.
Let me ask you this. I mean, what about the scenario, which I think is a reasonable scenario, that let's say I get into the back seat of the car, I have what was this, a Glock, you said, a Beretta?
A Glock.
A
A Glock, big gun, kind of a, nice gun. I have it in my, and it's uncomfortable to sit down with a gun in my belt like that. So I take it out and I just put it on the seat. I mean, if I just go like that, you're talking 2 feet already. That's a reasonable scenario. Why would not that expose the defendant to possession?
Well,
Actual possession in that case, actually.
Justice Labarga, that may well have been what happened in the case, and it may well have been that my client got into the car and it was there, and it may well have been the case that the 2 children in the front saw the officer in plain clothes go around the block. It took a minute or two, ample time for anyone who wanted to disassociate himself from the firearm simply to put it in the back. And that is an entirely reasonable hypothesis of what happened in this case. The problem is that the state doesn't have any independent proof to show you and to show a rational fact finder beyond a reasonable doubt that it was in fact within my client's control. You could say the same about the Uber example, the Lyft example. A child gets into the back of the car, any passenger gets into the back of the Lyft and is now suddenly, under the state's view, sort of master and commander of the entirety of the back seat and every single item within it. We think that that rule is untenable, and it's not as though they need that rule to see justice served in cases like this, because we know that they have a whole arsenal of investigative tools at their disposal. They can DNA and fingerprint the gun, which, particularly in a case where you have a child who volunteers and is cooperative and offers the DNA.
But they did in this case, it just, they didn't come back. For some
Right.
reason, the lab result did not come back in time for trial.
Correct.
But what's the relevance of that? I mean, if the question is control, what if there had been someone else's fingerprints on the gun? I mean, ownership and control, you're not saying that that there was an element that it had to have been his gun, right?
What I'm trying to suggest is that we have a clear majority rule, we have an excellent reason for it to prevent wrongful convictions, and to the extent that the state wants to prosecute these cases, it's not as though we're imposing some barrier on them where people are going free in these cases. Simply do the investigative steps necessary. Fingerprint, DNA test the gun. They can ask.
But to what end? I mean, what would that, given the elements that are at issue, what difference would that have made?
Well, it would be independent proof, Your Honor, of dominion and control if my client's fingerprints were on the gun. At that point, I think a rational fact finder can find beyond a reasonable doubt that my client in fact controlled it, as opposed to simply this sort of guilt by association theory. You're in the back seat, and we're going to infer that you possessed everything.
So a judge would have to deny a JOA based on the fingerprints being on the gun.
Exactly, precisely.
What-
Precisely.
If the state, because I think your opposing counsel said that if the fingerprints had come back and shown that they were the driver's gun, that the state would still prosecute. What's your position on that?
We think then we would be in the exact same position as here. It makes our case, I think, somewhat stronger, but one way or the other, unless my client's fingerprints, but it doesn't just come down to that. There are any number of ways that they can prove their case. If they want, they can call the driver and the passenger at trial, have them deny it, and now we have a classic credibility question for the fact finder to decide. The fact finder can credit their testimony. That draws the reasonable inference that it was in fact my client's if they're denying that it was theirs. There are any number of things that they can do to prove their case. The point of the matter is that they must prove their case.
Let me ask you this. If it had been a sole driver, and it was a bench seat and the gun was the same distance away, what would you say in response to a motion for judgment of acquittal at that point?
A single person in the car?
Yeah.
We believe that that will go to a fact finder. We have absolutely no problem with that hypothetical.
No problem with that. What if there's a driver, same scenario, gun, same distance on the front seat, but there's a back seat passenger behind the driver, no front seat passenger?
It's obviously a more difficult question. I think you might be able to say that a driver has greater control over the car than a passenger. That would accord with, I think, social custom and reason. So that might be able to go, although I think it's still a very strong case for the defendant in that circumstance. But if I could take you back briefly and sort of close the loop
I mean,
on...
that's sort of important because we're going to give directions to judges, and judges are going to have to decide as a matter of law if there's... So I'm just curious, in that hypothetical, front seat passenger, back seat passenger, a front seat driver, no other front seat passenger, back seat behind, guns in the same position as your client's was in the front seat, can someone drive like that with the gun right there on the seat and know that they cannot be prosecuted for that gun in ready reach?
I think that under the plain language of the jury instruction as written and as the courts have applied the rule, the answer would be that does not get to a fact finder because it's simply within ready reach but no proof of control. That's a mere proximity case, just like 1 to 2 feet in the back seat is a mere proximity case.
Okay, and I would agree with you, whether it's the front seat or the back seat, it doesn't matter on the legal issue. So if we accept that control means what you say it means, then it's not a crime to drive with a gun right there next to you as long as there's a back seat passenger.
Well, it would be a crime. The question in all criminal cases is can they prove the crime? But
So when Justice Lawson says control means what you say it means, what do you say control means?
we think that, like in Chacon, it means a conscious and substantial possession. The jury instruction now says direct personal power to control, which does not just mean being near something, because we all know in the laptop hypothetical in the back seat, I don't control my friend's laptop. It's his, I know that I don't touch it. And to sort of close the loop on that hypothetical, if I'm sitting 1 to 2 feet from the laptop in the back of the car, the police show up and lo and behold, the laptop is stolen. I most certainly am not liable for possession of recently stolen property. That cannot be a crime, and I think that any rule that allows me to be convicted of that, knowing that I'm fully innocent, is a very poor rule indeed.
Do you see a difference legally between this case and probable cause cases like State Reed Robinson of the Fifth DCA?
We do, and the reason for that is exactly what the United States Supreme Court said in Pringle, which is that finely tuned standards for trial, like beyond a reasonable doubt, have, quote, no place in the probable cause decision. So that's a vastly lesser evidentiary standard. This would be a much more difficult case if the question was probable cause, and there would be cases like Maryland versus Pringle that may or may not control that. But what they need in this case, and this is what you said in Pagan, what they need is proof to get to a fact finder, proof from which a rational fact finder could find beyond a reasonable doubt dominion and control. and that's what they don't have.
Do you, Mr. De Souza, do you believe that in the hypothetical where you have the driver, and the driver's the only person in the car, but the gun is in the back seat, is it distinguishable because the driver is the owner of the vehicle? Could they then be prosecuted?
You have said in cases like Brown that ownership does matter, is significant to the analysis. So if there had been no proof that someone else had been in the back seat, I think the state might be able to win a conviction there. That would look very different from what we have here. But at the end of the day, what you have here is a 15-year-old boy. This case looks in all respects like the exact reason that we have this rule to begin with. A 15-year-old boy sitting with friends, some of whom may have been involved in a crime, throws the gun in the back seat when the cops are going around the block, and now the gun is being pinned on my client. That case does not deserve to go in front of a fact finder, and we're asking you to approve the Third District's decision. If the court has no further questions.
But our role here isn't to sort of hypothesize things that aren't in the record as to, any conceivable scenario of how the gun would have gotten there, right?
That's correct. However, I think effectively what the state's rule would allow is jurors to guess to get to guilt. Because no rational fact finder in this case could say, I know what happened. I know that it was DV possessing the gun in the back seat. They would have to guess to get to guilt.
But they don't need to know, quote unquote, what happened. Isn't the question whether he controlled the gun?
That is precisely the question. And what I'm submitting to the court is that no rational fact finder could say, and say beyond a reasonable doubt, that it were his, as opposed to the fact that he were just merely present.
But you've conceded that ownership is not the issue, right?
I agree, it's possession.
Okay.
It is possession, but again, even under the ready reach theory, they need both so close as to be within ready reach and the additional aspect of that, which is also under the control.
So your position is that no rational juror could think that if I just go like this and can grab the gun, that I'm in control and possession of that gun. No rational juror could come to that conclusion.
Well, they need to be able to reach that conclusion beyond a reasonable doubt. And under the facts of this case, we know that my client is a 15-year-old boy in a small automobile. It's a car. It's not an SUV or a van. The gun is behind the driver's seat, 1 to 2 feet from him, is what the fact finder found. So a juror would have to, I'm not sure I don't know how they could possibly get there. A rational fact finder could get there unless they're guessing, which the law doesn't allow.
I mean, we instruct jurors and have for decades and longer that a reasonable doubt is not a speculative doubt. It's not a possible doubt. And I guess that really may be the issue, is does that go to speculation that somebody in the front seat could have put it back there? Is that a speculative doubt as a matter of law? Or does it go to the jury and can they decide whether it's reasonable or not? Is that correct?
Justice Lawson, my laptop hypothetical shouldn't go to the jury, because there's just no way to say that it's mine as opposed to anyone else in the car. And a firearm is not qualitatively different from that. I think their rule fundamentally comes down to, I'm a passenger in a car, suddenly I am master and commander of the entire area of the back seat and every single thing within it. That's the only way that you could send this case to a jury if you accept that.
In any case involving a car, there's always going to be a possibility you could speculate about people if they're in the front seat sort of turning around and grabbing it. So, I mean, is that, what should we make of that?
Well, I think we already have a rule in Florida. It's the clear majority rule that says mere proximity is not enough. We're just asking for a very straightforward application of that rule, that simply being by it is never sufficient proof to convince a fact finder beyond a reasonable doubt. Thank you so much for your time.
Thank you.
Very briefly, at the motion for judgment of dismissal stage, all inferences are to be drawn in the state's favor. So the questions about what is a speculation, what could we make of this inference that has two competing ways to see it, the trial court had to draw that in the state's favor. So if the court has any more questions, we ask that the court follow RDD and reverse. Thank you.
Thank you.
Thank you. Thank
All right,
you.
we thank you both for your arguments. We will now move to the second case on today's docket, Knight versus the state of Florida.